What did I just say?
There, and when it was told.
Listen to my question. Listen to my question.
This case opens with immediate tension, and that's not accidental. Right from the first words, Judge Simpson is already asserting control, signaling that this courtroom will not tolerate confusion, interruptions, or side narratives. We're dealing with River Ridge versus Timothy Kelly, a landlord-tenant dispute that has quietly escalated into something much bigger than a routine possession case. On one side, a corporate property management entity alleging repeated rule violations, statutory breaches, and disturbances. On the other, a self-represented homeowner claiming retaliation, financial hardship, and the potential loss of the only asset meant for his disabled daughter. What makes this case compelling is not just the legal complexity, but the imbalance of power. Mr. Kelly is unrepresented, unfamiliar with court procedure, and clearly overwhelmed, while the plaintiff arrives prepared, procedural, and confident. This is where landlord-tenant law becomes unforgiving. Rules of civil procedure apply equally, regardless of income, age, or intent. And from the jump, Judge Simpson's tone suggests he already sees procedural deficiencies that could decide the case before it ever reaches trial. As you watch, pay close attention to how often the judge redirects Mr. Kelly back to the question and how frequently the conversation shifts from facts to procedure. That tension between story and structure is going to define everything that follows. Who do you think the system favors when procedure clashes with personal hardship?
River Ridge versus Timothy Kelly. My goodness. Take your appearances, please.
Rachel Dornbush, Palace Law, 7301 on behalf of the plaintiff.
Your name, sir?
I'm Tim Kelly, yes.
All right.
Sorry, Your Honor.
No, not a problem. Ms. Dornbush, you guys can have a seat. Ms. Dornbush, it is indeed a pleasure seeing you actually in person and not in a little box on my screen.
I was telling Mr. Pallets yesterday that my last appearance in your courtroom was the last day we had in-person proceedings before COVID. This Friday, March 13th, 2020, and we were in this courtroom because we had to
Go back and forth.
Yeah.
Amazing.
Yeah, so
It's been a while.
7 months ago.
Yes. Okay, so where are we on this case?
Your Honor, I think today is the date and time for, I think, a settlement conference.
Yes.
As of the last date, Your Honor, given plaintiff an opportunity to file a reply to Mr. Kelly's answer, which got done, setting forth deficiencies in the answer, what I would call admissions in his answer, citing additional grounds on which the plaintiff has to terminate Mr. Kelly's safety. The most serious of which, Your Honor, is based on the revocation of Mr. Kelly's driver's license, which I believe occurred in 2022, and he's certainly been driving his car in the community over the last 2 years, and that violates Michigan statute and the lease and rules and regulations clearly state that a violation of Michigan statute or any other ordinance, local, state, or federal, is grounds for termination of the tenancy. So I don't know that there's a tribal issue in this case, Your Honor. For that reason, we would be asking for a judgment session today.
Mr. Field.
I can't hear a word she's saying. I'm sorry, Your Honor. Like 40% hearing, trying to get a hearing aid right now. This?
Oh, no.
Like this. Got it. Sorry. That's much better. Thank you.
I was going to have you do it the other way. Sit here and laugh. Anyway, all right. Could you briefly surmise what you just said, Mr.
Yes, Your Honor.
Sorry.
Your response, Mr. Cup.
Your Honor, none of that was brought up in the initial complaint back in July.
This is a textbook frustration point for self-represented litigants. Mr. Kelly is arguing fairness, essentially saying, I didn't know this was even an issue. But courts don't operate on surprise or perceived fairness. They operate on pleadings. If the plaintiff's filings legally allow them to rely on newly discovered violations tied to lease provisions, the court can consider them, even if the defendant feels blindsided. What's striking here is Mr. Kelly's honesty. He admits he hasn't researched the statutes or community guidelines. While that transparency may seem admirable, legally, it's dangerous. Courts assume parties know, or are responsible for knowing, the law. "I didn't know" rarely protects you. At the same time, this moment exposes the human gap in the system. Mr. Kelly is reacting emotionally and logically, not procedurally. He's defending intent rather than compliance. And that mismatch is exactly what the plaintiff's attorney is exploiting.
So she hasn't brought up one thing that the original complaint stated. So, I don't know where the laws come in as far as my license and everything, but
Pardon?
I say I don't know where the laws lie as far as I haven't researched anything in the Michigan state statute or the community guidelines that mentions anything about driver's license. That's because this is the first I've been accused of that. I mean, it's all the first time it was brought up, and that recently happened, and I don't have to own my car anymore. So
What recently happened?
that my car was taken away or not impounded, repo. Go ahead, I'm sorry.
I may reply to that. Your Honor, our reply to defendant's answer does set forth the ongoing grounds listed in the original demand for possession, which Mr. Kelly failed to respond to several of those. In his answer, Your Honor, very vague responses to the complaint for possession. 1. 2, Mr. Kelly does not respond to the claims that he's part of the law, that he's been disturbing other residents, and that he has verbally abused threat management and their personnel. Doesn't respond to that at all in the complaint, or in his answer. He makes no statement in support of his claim of retaliatory eviction. The original demand for possession, Your Honor, does state that we would rely on those being specifically delineated, but it also indicates that we would rely on any other violations that he becomes aware of. At the time that this demand was issued, the plaintiff was unaware of some ongoing issues with Mr. Kelly not having a driver's license. And so now the plaintiff is aware of those, they are going to be relied upon in this case.
I did respond to those as calling them false. I mean, there is one statement there. I didn't know if that should have been brought up with my answer or brought up in the trial. Negate those accusations properly, because they don't stand up to the truth. None of them. So I did state that in the answer.
Your Honor, the Michigan Court Rules MCR 2.111A require a clear and concise answer. The same rule, subsection D, requires the defendant to state the substance of the matter he's going to rely upon in defending a complaint filed against him. 2.111F requires defenses to be pleaded. It also indicates that allegations that aren't addressed are deemed as admitted. Because Mr. Kelly did not specifically.
This is one of the most critical legal explanations in the entire hearing. Under Michigan Court Rule 2.111, a defendant must respond specifically to each allegation. Silence or vague denials are treated as admissions. That means the court doesn't weigh credibility. It treats unanswered claims as fact. From the plaintiff's perspective, this is devastatingly efficient. They don't need to prove everything at trial if the paperwork already establishes it. From Mr. Kelly's perspective, it's catastrophic. He believed trial was the place for evidence, but civil procedure demands that defenses be laid out on paper first. Judge Simpson's patience is thinning here, and you can feel why. The court isn't evaluating whether Mr. Kelly is a good person. It's evaluating whether the pleadings create a triable issue. And right now, the judge is signaling they do not.
He doesn't make any specific statements at all regarding claims against him. Again, a vague assertion that they're false, but how are they false? There is nothing in his answer to support his claim that these allegations are false.
I did go through each step that they were claiming and disagreed with them. I mean, I thought that's what the answer was supposed to be as far as the state guidelines and the community guidelines. I didn't know I had to choose one. I thought that would be brought up in trial when I could bring evidence.
No, sir. That's not how it works.
If I just answered that these aren't true, each one, yes, I mean, I don't.
Well, you have to specifically lay out what your answer is, not just some general denial of everything.
Well, I don't see anything true about it. It's, it's under the guise of upon information and belief, which is, it's just hearsay when the bottom line. So I didn't, I don't have a lawyer. I can't even afford a lawyer. So I'm trying to do it myself, Your Honor, but.
This is the emotional heart of the case. Mr. Kelly lays bare the reality millions face, navigating a complex legal system without representation. But Judge Simpson's response makes a harsh truth clear. Lack of counsel does not excuse noncompliance. Legally, the court cannot act as Mr. Kelly's attorney. Judges must remain neutral. Emotionally, though, this creates visible friction. Mr. Kelly wants understanding. The court needs structure. And every time he explains context instead of answering directly, he digs deeper. Audience engagement. Should access to legal counsel be a prerequisite in cases where someone could lose their home? Or is personal responsibility the final word?
All that, I have phone numbers and all kinds of things that you can call if you want to verify my reputation as a decent human being.
When did you stop driving? How long has it been since you haven't driven a vehicle?
I'm getting my license back to the state for quite a while. I don't have any means to get to it.
So you haven't been driving for how long?
It's probably 2017.
So you've not driven a vehicle since that time?
Take the fifth on that.
Okay.
Well, I mean, I got pulled over I went to Bush's. It was for an emergency. I have a daughter at home. Stays with me off and on. And as far as that goes, I
Got pulled over in Saline. Yeah.
I was driving that day just to go to Bush's
In August.
to get groceries. Yeah.
In August, right?
Yes, in August. I'm a senior citizen on a fixed income, and it's very hard. Everybody wants lawyers or money, and I just don't have it.
You really haven't stated anything here. You say that they're retaliating. You've not stated anything regarding a retaliatory eviction.
Well, the reason I didn't, Your Honor, was because I thought that would be brought up in trial. I'd be happy to.
No, sir.
Well, okay, I could talk about it now. I mean,
That's not how this works, Mr. Kelly.
What do you want me to go through each one, even though they're false claims? I mean, I don't know how to do anything else except deny that what they're saying is not true. Now, the retaliation came the day after Miss Smith and I got into a little scuff on the phone, and the next day I have a big thing on my door saying that I'm gonna be evicted. There's false allegations there that I can very easily prove wrong. One, I've never ever threatened an employee or her in any way,
Mr. Kelly,
shape, or fashion.
Mr. Kelly.
Yes.
If I set this for a trial and you lose, you're out in 10 days.
This is the moment the stakes become unmistakably real. Under Michigan law, once a judgment of possession is entered, tenants or occupants often have as little as 10 days before eviction proceedings move forward. That clock doesn't pause for appeals, emotions, or unfinished explanations. Mr. Kelly finally understands the timeline, and panic enters his voice. He's not just defending his residence, he's defending an inheritance for his disabled daughter. That emotional weight contrasts sharply with the procedural rigidity of the court. From a legal standpoint, Judge Simpson is doing exactly what he must, informing the defendant of consequences. But from a viewer's standpoint, it feels like watching someone realize the floor is disappearing beneath them.
You know
I'm
that.
out in 10 days anyway, from what I understand.
What?
If I defaulted or you judge for the plaintiff or side with the plaintiff, I thought I had only had 10 days anyway. What? Is that true?
Yeah, it's 10 days under statute.
Well,
So-
that's another reason that I feel I have to take it to trial. I mean, my outside of my house is perfect, but the inside needs a little work. And if I was going to sell it, I'd take a huge loss on that. If I had to get out in 10 days, find somewhere to live. I have a dog there. I've been there since 2017, Your Honor. This is the third corporation that's owned it or managed it. I wasn't written up once in those first.
Mr. Kelly, what do you want to do?
I want to
They don't want you there.
I want to save my house. I want to stay there. I mean, I retired. I put everything I had into that house. I paid my life savings to buy that free and clear so I wouldn't have a mortgage payment. I mean, I was planning on dying in Saline, you know, I mean, there. And it's in a trust. It's in a trust beneficiary, Your Honor, for my daughter. It's the only thing I have to leave for her. She's a disabled minority. She doesn't have anything that's going to be left to her except that house. And that's my plan, is to leave it to her. And I don't know, you know, between Pamela and I, we used to get along great. I mean, I haven't been able to even speak to her, so I just don't. I'm kind of confused as to, she knows my situation. She knows my daughter. She's fed my dog when my dog comes up. We had a good relationship, and all of a sudden she doesn't even want to talk about it. So I mean, I feel that it's awfully extreme. I mean, I cut the lawn for 4 older women there, and then I have everyone around me.
Mr. Kelly.
I just think I'm not the type of man they're making me out to be, Your Honor. How else can I come here and
Well, your pleadings are bad. And I could frankly find that I don't have a tribal issue and grant them a judgment today.
This is nearly checkmate. When a judge says there may be no triable issue, it means the case could end without a trial, based purely on paperwork. For Mr. Kelly, everything he wanted to say, prove, and explain suddenly becomes irrelevant. Judge Simpson isn't questioning Mr. Kelly's character. He's questioning whether the court even has something legally valid to decide. That distinction matters. Courts resolve disputes, not narratives. This moment underscores the brutal efficiency of civil litigation. Sympathy doesn't substitute for compliance. And once the judge reaches this point, the outcome often becomes procedural inevitability rather than factual debate.
Sorry, Your Honor, could you repeat that? I didn't hear you, I'm sorry.
Your pleadings and your filings are bad. They're missing all kinds of things. It doesn't present to me an issue that I could even try at this point.
Well, I can't even keep up with the paperwork between the being, you know, the monetary things that I get every month. I mean, I've been going to court. I've been before you for the last 6 months. I mean, it's hard to keep up with all their paperwork. I apologize, but I didn't know that, you know, I can't afford a lawyer. I'm trying to do the best I can. I thought that I could, you know, I can bring you evidence of negating some of that stuff in trial. I didn't, you know, if you want me to answer that and give you
I told you to answer before, and I don't have it. Actually, I told you, I think, twice.
Oh, you do have it, Your Honor, because you found it at the last hearing. We took a recess because you didn't have it, but then the court clerk.
That's not what I'm talking about.
Oh, I'm sorry.
Your answer is wholly deficient.
Okay, I apologize. I was up all night. I don't know, really. I'm not an attorney, so I thought by just telling you that, I mean, I don't know how to answer. Some of those aren't accurate to the facts, so I didn't know if you wanted me to just state without any evidence to, to negate their claims. I didn't think you needed me to just say, what went on there, because I couldn't bring you any proof of it. So I didn't know that. I can present evidence and all of that if you give me time.
What would you present to this court, Mr. Kelly?
Well, I could present the fact that the claims that they filed are false. For instance, the car on the lawn, the threatening of the employees. I don't have all of them in front of me, but I could prove that those aren't true. And there's been other write-ups that through the.
Suppose you have a photo.
We do have a photo. It's his mother-in-law's car. It was towed last year after many months and notices that the car needed to be removed. My understanding, Mr. Kelly, please let me finish, is that when the tow company came out to remove it, he threatened the tow company. Now, I'm still trying
That's
to.
a lie. That is a lie, and I can prove it wrong because I spoke to the Mayflower towing guy, and he denied that he ever said that. In fact, Ms. Smith said that he told her that he told her that I pulled the gun. Yeah, what is this? The car? I'm not denying the car. I'm denying that the fact what they said.
Mr. Kelly, you just
gave me permission, Your Honor, for that car to be on the grass. She knew that it was my ex-wife's mother's car, and she just passed away, and she didn't have anywhere to put it. And I had it on my driveway, leaking a little oil, so I just moved it. Now I repaired that lawn, and it's a beautiful looking car if you saw it, but she was aware of it. Now, there was some controversy the day that it got towed because I was asking her to please wait because my ex had called me and she called.
If she gave you permission, why would they have it towed?
Because it took.
Why would they have it towed? If what you said, Mr. Kelly, if it's true that they gave you permission to have it there, why would they have it towed?
It was. Your Honor, I could prove that it was.
It does answer my question.
It was towed because it had come to the point where it was on the lawn. It was there too long. And she said that she stamped the car. The car was there for a year, Your Honor, on that lawn for a year. And then she put a tag on the car. And that's when we started negotiating. And I called my ex and told her, you got to get this car out of here. They want it out and it's going to be towed. That was when it came to that point.
Mr. Kelly.
But it was on the lawn
Mr. Kelly.
A year, Your Honor.
Mr. Kelly.
Yes.
You told me 3 different things about this car.
This exchange marks a turning point in how the judge views Mr. Kelly's credibility. Up until now, the court has focused primarily on procedural failures. But here, Judge Simpson shifts into fact-finding mode, and what he's hearing doesn't add up. Mr. Kelly's explanations about the car, permission, timing, duration change with each answer. In court, inconsistency is far more damaging than a bad fact. A single violation can sometimes be explained away. Multiple conflicting explanations cannot. Legally, the issue isn't whether the lawn was maintained or whether the car looked nice. The issue is compliance with community rules and written notices. Once the plaintiff introduces documented violations, dates, and follow-up notices, verbal explanations lose their power. Courts rely on records, not recollections. This moment also shows how self-represented litigants often hurt themselves by over-explaining. Instead of directly answering how long the car was allowed to remain, Mr. Kelly drifts into justification, history, and personal circumstances, none of which answer the judge's question. Engagement question. At this point, do you think the judge believes Mr. Kelly? Or do the inconsistencies outweigh his explanations?
You're telling me that they gave you permission to have it on there.
Yes.
So how long, presuming they gave you permission, how long were they allowing you to keep it on the property?
There wasn't any set time. It was there. I kept the lawn. I always whipped around the car. I cut the lawn. When the car was gone,
I didn't ask you about the lawn.
I repaired the lawn.
I didn't ask you about the lawn.
There wasn't anything in writing or set. It just came to the point where it was there too long. Like I said, Pam and I got along fine. And then it was getting to the point, look, that car has been on there, or the car has been sitting there for too long. It didn't have proper plates. And that's when they put a tag on it and they gave me 10 days to get it out of there.
And did you?
I was my ex-wife. Yes, she was in the process of getting it. And I had no.
You talk in so many circles, Mr. Kelly.
I'm not talking in circles.
You absolutely are.
You're asking me what happened, and I'm telling you.
I didn't ask you what happened. I'm asking very specific questions, and you're not answering.
I'm telling you.
You take off going in another
I
direction.
didn't have anywhere to put.
Why do I care whether you weed whipped around the car?
I guess you don't.
I don't. I didn't ask you that.
Well, they're making it out like my property's a junk pile, and it isn't. It's one of the nicest kept up yards in the area.
Did I ask you that?
I'm sorry.
First off, there's nothing in any of our pleadings in any way, shape, or form alleging that his site looks like a junk pile. So no, that is absolutely false. Your Honor, I have here a rule violation issued December 30th, 2022, no parking on the lawn.
This is where the plaintiff locks the case down. Dates, written notices, emails, and follow-ups are the lifeblood of civil enforcement cases. Once those documents are read into the record, the argument shifts from what happened to what was ignored. The timeline presented here shows months, sometimes over a year, of alleged non-compliance. From a legal perspective, this undermines any claim of surprise or retaliation. Retaliatory eviction claims require proof that the landlord acted because of a protected activity. But when violations predate the alleged conflict by months, that argument becomes extremely difficult to sustain. Notice how the judge listens here. There's very little interruption. That's telling. Judges give space when they're hearing something that fits neatly into legal standards. Compared to Mr. Kelly's circular explanations, this presentation is clean, chronological, and supported. Audience engagement. If you were the judge, would this paper trail outweigh everything Mr. Kelly has said so far?
Rule violation issued on January 12th, 2023. No parking on the lawn. There's a note that they also emailed him about the dog being outside on tie-out, also a violation of the rules and regulations, and the vehicle being on the lawn. On 2/1, he called and said he will remove the car within 1 week. On 2/16, the car was tagged. I don't know the exact date that it was towed offhand, Your Honor, but April 23rd, Your Honor. So many months after all of this. So Mr. Kelly had ample time to remove the car, and he didn't.
My ex was speaking with Miss Smith, and it was kind of between them at that point.
No.
I'm talking about the last. You can ask her. My ex talked to her. They were
Mr. Kelly.
They were talking
Mr.
back
Kelly.
and forth. Her mother died here.
Mr. Kelly.
Yes.
They told you to get the car off the lawn.
And
They told you you were in violation.
And I
You
did.
did nothing.
I did get it. It was towed.
Who towed it?
Mayflower Towing.
Okay.
At that point,
Bad question.
I said,
You want to know what?
I was trying to save
This is why
some money.
Mr. Kelly,
Yes.
you're never going to overtalk me.
I'm not trying.
No, you are.
It just seems like just a man trying to save my house, Your Honor.
Mr. Kelly, you told me about that vehicle. I just take that. What they told me is what Mr. Ormber's laid out. You weren't telling me the truth.
I am telling you the truth.
No, you're not. Why would she give you permission to park on the lawn and then send you a notice that you're in violation?
Because Honor, I can give you proof of when the car was there and when it was towed.
Listen to my question.
It was over.
Listen to my question.
Go ahead.
Oh, no. Mr. Kelly, you better check that attitude right now. You better check it.
This moment is explosive. and pivotal. Courtrooms demand respect, not just in language but in tone. Judge Simpson's reprimand signals that Mr. Kelly has crossed from frustration into defiance. Even unintentional attitude can be interpreted as contempt when a litigant repeatedly interrupts or challenges authority. Legally, this matters because demeanor influences discretion. Judges have wide latitude in scheduling, continuances, and procedural leniency. When patience wears thin, that discretion tightens. What might have been a warning becomes a consequence. From a human standpoint, this is tragic. Mr. Kelly is spiraling under pressure, but courtrooms are not therapeutic spaces. They are rule-bound environments. Emotional authenticity, while understandable, often backfires. This is also the moment where the power imbalance becomes undeniable. One misstep in tone now carries legal consequences.
I'm not trying.
You better check it, Mr. Kelly. Oh, don't. Oh,
I don't know
Oh,
what
no.
I'm doing wrong.
Here's one thing that you've done wrong.
Please tell me.
Here's one thing that you've done wrong.
What?
I am not going to have that attitude coming from
I
you.
don't.
You need to figure out what you're doing. You have interrupted me throughout these entire proceedings. I'm not going to have it. Outside of the fact you've got a warrant for your arrest.
I apologize, sir.
You got a warrant.
I didn't know that.
Yeah. It's from the driving while license suspended.
I had.
So here's what we're going to do.
Sorry.
Just so happens the judge is in front of his next door. But right now you're going to go into custody. We're going to take you in. I'm going to go next door, talk to Judge Freshour, see what she wants me to do with you.
Please, Your Honor, I have a gun. I need to wait.
What did I just say?
I just checked with the court about a warrant.
Court's going to stay in a brief recess. I'll be right back. River Ridge versus Kelly. I had to check with Judge Freshour. We will be releasing Mr. Kelly not until 1 o'clock today. I'm not going to hold you guys here.
This is Judge Simpson exercising measured discretion. Despite everything that's happened, the procedural failures, inconsistencies, attitude, and warrant, the court chooses not to hold Mr. Kelly unnecessarily. Instead, the judge coordinates with another courtroom and sets a path forward. Scheduling a bench trial is significant. It means the judge, not a jury, will weigh evidence. That can cut both ways. Bench trials move faster and rely heavily on documentation. Given the plaintiff's paper trail, that's an advantage for them. At the same time, the judge explicitly allows Mr. Kelly to bring whatever evidence he has. This may be the last opportunity for him to substantiate his claims. But without properly amended pleadings, even strong evidence may arrive too late. The system is still open, but only narrowly.
What I will do is I'll set this, Ms. Dornbush, if you're available for a non-jury trial on the 30th. Will that work? Just doing that so you have to come back and see us.
Your Honor, we don't mind coming back at 1 if Your Honor wants to do that, but I mean, if it's for the purpose of doing a bench trial, we don't have all of our witnesses that we.
Right, and I think I'm gonna do a bench trial, let him bring what he wants in and
Should get our witnesses
all
together.
right.
So the
October 30th, 2024 at 9.
This case leaves us with a sobering takeaway. In civil court, procedure is power. Timothy Kelly's story is emotional, sympathetic, and deeply human, but courts decide cases based on rules, filings, and evidence submitted on time. Judge Simpson made it clear that good intentions do not substitute for proper pleadings, and that credibility is built through consistency, not explanation. The plaintiff, River Ridge, demonstrated how documentation, timelines, and statutory references can shape outcomes long before trial. Meanwhile, Mr. Kelly's lack of legal guidance left him vulnerable at every turn, culminating in a moment that changed the entire trajectory of the hearing. As this case heads toward trial, the outcome will hinge less on emotion and more on whether Mr. Kelly can legally rehabilitate his position before it's too late. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.